Good morning, everyone. Thank you for showing up on this beautiful Saturday morning. I know we have so many things happening every week that sometimes it becomes hard to choose which sessions to come in and attend. But personally, I think, this is one of the topics which I am personally extremely interested in. And reason is very simple, actually, that just like financial jargon and finance, which is full of complexity for many of us, and also because it's one of those things which you can keep avoiding all your life, not learning about money, but there will be a point in your life that you will have to face the reality. I feel law and everything legal is very similar to that. It's complex, it's full of jargon, and however much we want to avoid it in our life, there is a point that you will be faced with having to sit across lawyers and having uncomfortable conversations. So today's session, personally for me, is extremely important. Thank you so much for the team at You Are Insured for actually connecting with us in the first place. This was, their end to end, their effort. They reached out, they said, this is important for your community, you must do this. And I think it was literally a match made in heaven. So thank you so much for doing this. Just to, before I start, I just want to, if there are new people in the room who don't know anything about the company that we represent, I just want to share a little bit about Womoneysta. Womoneysta is a women first financial wellness platform. Um, we launched in 2020, and our main simple vision is to make financial decisions more inclusive in families and bridge the wealth gap. This simply means that, we are a big believer that women require financial power in their hands if they have to make truly freedom oriented decisions in their life. So that's why we started this platform. And the fact that we are still alive 5 years later says that there are a lot of women in this country and outside this country who do believe that there is a need for something like this today. What are the things that we bring to the table? We work with women in the space of courses, learning, community. If you're still not part of our community, please do go onto our website and we will share the community code as well in the chat box. Um, we also focus on one-on-one consultation. If you require personalized direction, guidance on your financial planning, you can definitely come and connect with us. And finally, we also started managing investments of women. I'm very happy to say that probably we're one of the only companies in this space in the country which manages upwards of 85% wealth, which is exclusively of women, and the remaining 15% are men who the women have brought in to our company, right? So that's something which we are very proud of. We have worked with women to become first time investors. I come across women who say, I was the first person they learned stock investing from or mutual funds from. And it's such a beautiful feeling to see the change that we're bringing. I think largely the thought is to break barriers. If women can go and break barriers in every front, then why not with money? So that's a little bit about us, what we're building. Please, the ones who've been there, who know Womonista for many years, of course, you know this and you've seen the growth. But do share this with more women around you. I think one simple, nudge can make a world of difference to any woman in your life who just needs that little bit of push, that nudge from your side. So thanks so much for always, showing up and supporting us to help bring anything which is relevant for you, which will help you break barriers. And today's session is just exactly one of those things. So I'm not going to take more time. I'm going to introduce our speakers and we're going to start moving into our conversation today. Just give me a second. Yes, Vaishnavi, you can share your screen and I will just introduce the two of you, the speakers that we have in today. So we have partnered with a company called You Are Insured, and they will be partners with us for anything to do with will planning or succession planning. The session will be hosted by the two founders, Sunil Pakalapati and Vaishnavi Yadav. So Sunil is the legal tech founder. He is, the technology head behind this platform. And when we spoke, he told me of something very interesting. I think very something which I resonated with, which is that why should planning for the estate or planning for wills only be kept for the high net worth folks? It should be something that each one of us, wherever we are, should have access to. And I think that's what they are working actively towards, which stayed with me. Of course, Sunil is an ISP alumni. He comes with the experience of having worked with marquee names such as Credit Suisse and Oracle. Vaishnavi is the legal magician in the company, so she's the chief legal officer, and I personally connect with, the one job that she's doing, which is making legal jargon easier for people like you and me. That's the work I do when it comes to finance, and I think that's what I'm looking forward to hearing from Vaishnavi today. The session is focused on helping us understand legal rights of women across different life stages. We've kind of curated it to help, right from a single person to a married person to someone who is going through a separation. We've curated the session in a way that it should be value for each woman in different life stages. So with that, not going to take more time. I will be handing the floor over to Sunil and Vaishnavi. Please, the floor is all yours, and the audience, I think, is up and ready. Ladies, you know the drill. Questions in the chat box. They'll be happy to take questions during or after as per their flow. Yes.
Thank you, Neha, for such a warm introduction. And I hope I can live up to what all you have said about me. So let's start with today's session. Why this session is important for all of us. As Neha has already informed me that you have already had a session exclusively on wills, so I will not deal with wills as such. But yes, I'll be very happy to take questions if you have any towards the end of this session. So through this session, we will discuss what succession rights you have in different stages of your life when you are a daughter or when you are married or are undergoing divorce or are a widow. Also, we will try to understand what are claims and what are the basic terms you should know when it comes to claims and what steps you should take to protect your wealth. So these are basically all the things that we are going to cover through this session. So what are the common challenges which women face during claims? The first one is emotional stress. A woman who is undergoing a divorce or maybe has lost a loved one, say a parent or her husband, she is already undergoing a lot of emotional turmoil. And on top of that, when she has to undergo these legal processes, when she has to look after the affairs in a legal manner, this at times becomes very overwhelming to her. Also, when such things happen, she has no clue or clarity where to start. She has never heard of terms like will, probate, legal heir certificate, succession certificate. All of these are very new to her, and she is somewhat lost when it comes to bringing all the things to the table. And this often leads to dependency on others. Also, when she goes through everything, she finds that sometimes the documents are missing. She knows there is a property, but she cannot have access to the papers. She knows there are shares, but she does not know how to access them. There is no written proof, or she does not have in writing what all she has, what all has been left to her name. Also, once she gets hands on these documents, sometimes it happens that these documents are outdated. You have undergone major life events. Maybe you have got divorced, or maybe you have changed address, or maybe there is a change in name. So sometimes all of these documents are outdated, and it becomes very difficult when it comes to settling claims with financial institutions. Also, she does not know what rights she has as a woman in various stages of life. She does not know on what standing she is, whether she is a class 1 heir or whether she is a class 2 heir, and what shares would she get in case there is a division of property. And when she understands all of this and goes to the government institutions, often she is told, Madam, you do not have this certificate. Madam, you do not have this certificate. So it leads to run from pillar to post in order to get what is already yours. But to claim it, it becomes very difficult and very challenging. To begin with, there are some misconceptions which I would like to clear at the very beginning of this session. The first one is, we often assume that the nominee is the legal owner. So we have nominee in various institutions like banks or demat accounts or say mutual funds. We all have nominees there. But it is often misunderstood that this nominee would be the legal owner. No, this nominee is only the guardian who will protect those assets or those properties until and unless the legal owners or the actual owners take possession of that property or assets. He is just there to manage them until and unless the true owners, the actual owners, come forward and claim it. The second one is, only wife and children are class 1 legal heir of the husband. No, this is not. Even the mother of the husband is class 1 legal heir. So it is the wife, it is the children, and it is the mother-in-law who will get equal rights in the property of the husband once he passes away. So if there is a wife, there is a child, and there is a mother-in-law, all of you will get 1/3 from the property of the male who has deceased. If there are 2 children, then each one of you will get 1/4 from the property of the husband. This is very important because sometimes they assume that automatically when the male member passes away, when your husband passes away, it is only you and your children who will get what is there in your husband's name. But no, mother-in-law also gets an equal share in the property. And then generally, we think that there is no need to update records or documents after major life events. Say there is a birth in the family, or some family member passes away, or you have undergone a divorce, or you became a widow. So we do not generally update these records, and it leads to major challenges when it comes to claiming. So think of a situation, you underwent a divorce and the nominee in your bank account is your ex-husband. You would say, I have already got divorced, and even if I do not update the nominee name in my bank account, nothing will happen because this person, if anything happens to me, won't get it because I'm already divorced. But you tell me one thing, who will tell the bank officials that you are already divorced and you are in no relation with this person? Also, it becomes very challenging for women because we tend to change our surname after getting married. So if say I am Vaishnavi Yadav now and I get married into a family which is Majji family, now if I change my name to Vaishnavi Majji, so it becomes very difficult if you haven't updated your records when it comes to claims, because in the eyes of law you will be 2 different people now. So it's very important to ensure that your name is same across all the institutions and that the spelling of your name is also same across all the institutions. Sometimes what happens is a person say Manju, in some of the documents it is Manju, and in the other documents sometimes it is Manjo. So similarly, in the eyes of law, these would be two different people. So once you go to the financial institutions to claim these, they would say, madam, the records are different. We cannot give you this amount. So these are common misconceptions, and I've tried to clarify them, and I hope you have understood. Now, over the next 7 slides, we are going to meet 7 different women in different stages of life and dealing with their own set of challenges. After meeting all of these women, I would like you to speak up how or by the use of what instrument, legal instrument, do you think this problem could have been fixed? So please be very attentive because I'm going to ask you questions after these slides. So let's meet Aisha. She is 26 years old and is unmarried. She is working in Bangalore and her parents are in Vizag. One day, Aisha's father unfortunately suffered a stroke and he has been bedridden since. Now, the only source of income for Aisha's parents has been a shop in a posh locality that they have given on rent. When the father suffered this stroke, Aisha came forward to handle the situation. And now, what she comes to know is that the tenant to whom they have let the shop, given the shop on rent, has stopped paying the rent for 3 months. She said, no problem. I will talk to the tenant and get the rent from him. Also, she gets to know that not only has he stopped paying the rent, but also he has sublet the shop. He has given someone else the shop to operate without taking permission from Aisha's father. Now, she says, no problem. I will go and talk to her since my father is bedridden and cannot take charge of the situation. So she goes to the tenant and asks him, sir, please give me the rent. So the tenant bluntly says, I do not deal with you. I deal only with your father and I will pay the rent only to him. Now, the father cannot go and meet him. Now, in this situation, Aisha couldn't take any legal action because she has no standing or locus standi in this matter. She could not initiate it and the tenant was happy and merry. He wasn't paying any rent to Aisha's parents and also he was enjoying all the revenue that he is getting from subletting this shop. So wherever Aisha was going for help, she was only told that, madam, unless your father authorizes you in writing, we cannot help you in this matter. So now you should work your brains and think, because I'm going to ask you after some time, what do you think? What could Aisha have done? What legal instrument she could have used in such a situation? In the meanwhile, we will meet Ria. She is 38 years old and is a divorcee. Although she is going through a lot in her life, but she is assured that she has a flat which she has purchased jointly with her husband while she was married to him, and that her finances will be taken care of, and this flat could come handy whenever she needs anything for her young daughter who is right now 8 years old. And while she was going through the divorce, it was mutually agreed between her and her husband, ex-husband, that she could take the flat, live in it, and do whatever she wants to do with it. Now, when her daughter has come of age, she wants to sponsor her higher education and she wants to sell this flat. When she goes to the broker asks her, madam, which portion of the flat is yours? She is taken aback. What is the broker asking me? the flat is half mine. But she comes to know that she cannot sell this flat because her share was never determined. This is still a jointly owned flat. She does not know which portion is his. If there are 2 rooms in the flat, which belongs to the husband and which belongs to the wife? It's a jointly owned flat. So, in the meanwhile, we'll meet Neha, and afterwards we'll also solve Riya's situation. So Neha is 42 years old and is married. Sadly, she loses her father, and she comes to support her brother with all the property mutations, with legal heir certificate and stuff. She is there for the moral support of her brother, and one day the brother made her sign some papers. She trusted her brother blindly, and she does not know what she was signing, but she was assured that whatever is happening, it is for the benefit of me and my brother. So one day she signs these papers, and one day she is casually sitting with her brother and says that, Bhai, I just want my kids to remember this house as their Nana's house. For now, you can have this house. We'll go with the final or division of shares later on. So the brother turns cold and says that, what are you talking about? You are already married. Just move on. You have already given up your share in this property. So she is taken aback what he is talking about. This flat belongs to both of us. This is our father's flat. And how can he say just like this? So he comes up and shows her a deed which she signed and says that, see, you have formally signed this flat in my name. So this is Neha's story. Now let's meet Priya, who is 45 years old and is a divorcee. After the divorce, Neha...
Vaishnavi, why do all the women look very sad? They're going through divorce, they should look happy. All pictures are sad women pictures.
But this is related to estate, right? Yeah. So...
You get used to my bad jokes. Go on, go on. It's okay. Just I noticed because each woman is getting sadder and sadder. So I was very concerned that in our tribe we make them all feel happy that
because
they
they
now have
do not
found
know
the
what
wealth.
their rights are in estate and planning. So therefore they are in a lot of confusion. After this session, maybe they are happy after knowing the rights. So here is Priya. She is 45 years old and is a divorcee. After her divorce, her mother brings her to her own flat, mother's flat, and the mother keeps assuring her that, Priya, this flat is yours and I want you to feel secure. One day, the mother suddenly passes away, and when she passes away, after some time, her brothers show up who were never around, and the brothers say that we all are legal heirs and you can't claim this house as only yours. So Priya is taken aback because she was always told by her mother that, Priya, this flat is yours and I want you to feel secure. And Priya has also invested her savings in renovating this flat. She was all secured. She was happy that at least she has some asset. But once the mother passed away, she was all taken aback because now the brothers wanted her to either vacate the flat so that they could sell it, or that Priya should pay them their share of the flat in money so that she could own the flat completely. So she was very sad and taken aback when she came to know about this. Now we meet Anita. She is 48 years old and her husband suddenly passed away due to a cardiac arrest recently. Yeah, thanks. So
Sorry.
her husband passed away suddenly due to a cardiac arrest, and the only relief which Anita feels is that he was a disciplined investor throughout his life, and he had substantial portfolio of shares and demat and mutual funds. All of these things he had invested in various places. So she was rest assured that at least my husband has left sufficient amount for me and my daughters, and that we could live our life without any financial hardships. But then she started contacting these various financial institutions, and each financial institution she went to said, "Ma'am, since your husband has not left any will, we cannot transfer or release these shares in your name. You will first have to get a succession certificate from the court, and then only you can have this money in your hand." Now we have Seema. Again, she is a widow. Her husband also passed away suddenly, and she has a young kid. And she was, although she has been going through a lot of turmoil in her life, but she said at least she could lay her hands on the bank account of her husband and get some money from there to go on with her daily life. When she went to the bank, the manager of bank said that, "Madam, we cannot release the funds to you directly because there was no nominee in this account. And to get your hands on this money, firstly, you will have to get the legal heir certificate from the court or maybe the municipal office. In Maharashtra, for legal heir certificate, you have to go to the court, and in all the other states, it is the municipal office." And lastly, we meet Kavita. She is 43 years old and is a divorcee. She is assured that, okay, although life hasn't been fair to her, but her husband has left a will in her name and has named her the beneficiary for their flat, which is in Mumbai. And now, at least, she will not have to run from office to office to get this flat mutated in her name. When she goes to the society to mutate this flat in her name, she comes to know that since the flat is in Mumbai, the will must be probated, and without this probate, the flat cannot be mutated in her name. So these are all the situations where showing where these women are placed. So let's talk about the first situation, Aisha's situation. What do you think Aisha could have done in such a scenario? What legal instrument could have come to her aid in such a scenario?
Power of attorney?
Yeah, exactly. Bang on. So here, Aisha's father could have given her the power of attorney to manage all his assets and properties. So what exactly is a power of attorney? In power of attorney, there are two parties. One is the principal and the other is an agent. What happens in power of attorney is the principal gives authority to the agent to manage his property on his behalf. It could be either financial transaction, it could be for a property matter, or it could be for a legal representation. So the authority is given by the principal to the agent to manage the property. Only the managerial rights are transferred. No ownership is transferred. And this power of attorney, it is not mandatory to get it registered. You can just get it notarized and go on with the flow. So it becomes very essential in such situations where a person is unable to manage a property. In such situations, he can use a power of attorney and give the rights to someone else to manage the property on his behalf. Going to the next situation, what do you think, Ria, which instrument could have fixed Ria's situation for a jointly owned flat? Any guesses? Okay. So it is the partition deed which Ria could have signed when she was undergoing this divorce. What is a partition deed? It is a legal instrument in which the shares are determined definitely. The parties get to know which specific portion is theirs. So their shares are defined and specified. Now they are on their own to take decision whatever they want to take with respect to their share. So once the shares are determined, they get to know that they can sell it, or they can mortgage it, or they can do whatever they want to do with this. They won't have to take permission from the other party, or they won't need assistance from the other party to move forward in such a case. So partition deed is very, very important when it comes to a divorce. If you have mutually you are owning a flat with your husband, or there are some joint assets in your name, it is very, very important and essential that you sign a partition deed then and there.
And
Now,
Vaishnavi, say in case we don't sign one, then what is the implication of that?
then the implication is that whenever you would want to sell it or mortgage the flat, you will have to bring in the other person to the table and get him also signed. So once your relations are already strained, you do not want to go through that turmoil once again, right? You will have to bring that other person to the table. You will have to request him to sign it. He may not be willing to,
Got it.
yeah. So
Can I
partition
also,
deeds is very, very important.
Neha, can I also ask one thing?
Yeah.
Yeah, I think Vaishnavi, let's take the questions as you're going through the cases because it stays
Sure.
fresh,
Yeah.
right? So, yeah, Richa, please.
Yeah, Vaishnavi, I want to ask, what if the partition is not possible? Suppose we have a flat of 2 BHK. So partition won't happen. It will not be feasible for both the parties to do the partition and later on sell it or mortgage it. In that situation, what we can do?
No, see, this is a partition deed. I'm not saying you to have a physical partition of that flat. In a partition deed, when you sign a partition deed, your shares are fixed. So,
But
yeah,
shares are also fixed, but until and unless we both the parties agrees on selling or on mortgaging, nothing will happen ना. ठीक है, हमने वो determine तो कर लिया कि 50% share is mine, 50% is of the another person. But until and unless हम अगर उस फ्लैट को बेचना चाहेंगे, until and unless both party will agree, तो वो वैसे भी नहीं हो पाएगा.
नहीं, पार्टीशन डीड में आपका शेयर फिक्स हो गया कि मतलब अगर 2 BHK फ्लैट है तो 1 रूम, लेफ्ट वाला रूम इसका है और राइट वाला रूम इसका है. वही पार्टीशन डीड का मतलब है कि आपका शेयर फिक्स हो गया और आप अपने शेयर के रिगार्डिंग आप कुछ भी डिसीजन ले सकते हैं.
I
तो
think what her
आप
point, what her point is, Vaishnavi, in a practical situation, आप आधा घर तो बेच नहीं सकते ना.
यस
आप बेच सकते हो, एक बेडरूम बेच देते हैं और दूसरा बेडरूम नहीं. So I think that's what Richa is saying. So Richa, in that
Yeah.
case, even a partition deed will not help. Actually, you
हाँ
have to sell the property
या इधर
when you are separating.
या
This kind of situation I think helps in like a builder floor situation. एक फ्लोर कि एक फ्लोर का राइट आपने ले लिया, दूसरे फ्लोर का राइट दे दिया. I mean, I'm just saying practically, just think of it. आधा घर तो नहीं बेच
प्रैक्टिकली
पाओगे.
ये होगा कि या तो आप अपने जो सामने वाला पार्टी है उसको आप पैसा देके उसका भी जो शेयर है आप वो खरीद लो, या फिर आप अपना शेयर उसको बेच दो, या फिर उसको आप मनाओ कि हम पूरा ही बेच के आधा आधा पैसा कर लेते हैं.
So
प्रैक्टिकली
that
ये होगा. या
मतलब practically mutual understanding of the other party is required compulsory. Otherwise, we can't do anything ना.
करेक्ट
वो
करेक्ट
तो
करेक्ट.
डिवोर्स में वैसे भी चाहिए रहेगी यार. तभी तो लॉयर्स बैठे हैं वो
तभी
अंडरस्टैंडिंग
तो
लाने
हम
के
बोल
लिए.
रहे हैं कि व्हेन जब हो ही रहा है ये सब, तभी आप अपना सब सेटल कर लो, बिकॉज लेटर ऑन अगर ये सब नहीं होता है तो इट्स वेरी डिफिकल्ट टू ब्रिंग बोथ द पार्टीज अगेन टू द सेम टेबल, राइट? तो जब हो रहा है उसी दौरान आप सब करो, और उसी दौरान आप मतलब यू टेक एवरीथिंग इन राइटिंग एज वेल। कुछ वर्बली मत करो कि हाँ ये हो गया वो हो गया, एवरीथिंग शुड बी इन राइटिंग। और पहले का पहले ही जब ये सब हो रहा है आप डिसाइड कर लो कि इसका क्या करना है, उसका क्या करना है। ज्यादातर सिचुएशन ये तब आएगी जब आपका एक कोई एसेट हो, बिकॉज अगर जॉइंट अकाउंट है तो आप उसको बंद करवा सकते हो। दिक्कत तब आती है कि जब एक एसेट है 2 BHK 3 BHK, तो उसमें बीच में दीवार कैसे खिंचेगी, वो दिक्कत आती है। अगर घर ऊपर नीचे का है तो आप ये डिसाइड कर सकते हो कि भाई नीचे वाला मैं लूंगा, ऊपर वाला आप ले लो। लेकिन अगर एक ही है तो यस, तब दिक्कत आएगी, क्योंकि आपको पहले ही डिसाइड करना पड़ेगा, या तो आप उसका शेयर खरीद लो या वो आपका शेयर खरीद ले, या फिर दोनों मिलके घर को बेच दो और पैसा आधा आधा कर लो।
और वन थिंग मोर, क्या हम पार्टनरशिप डीड में ये लिखवा सकते हैं कि इफ वन पर्सन वांट टू सेल इट शेयर, द अदर पर्सन कैन गेट द मार्केट वैल्यू, तो वो कर सकता है?
ये वही है कि आपकी म्यूचुअल अंडरस्टैंडिंग पे है। अगर जो सामने वाला ही इज ओके, ही इज विलिंग कि हाँ चलो ये ठीक है, तो आप लिखवा सकते हो पार्टीशन डीड पे, ऐसे कुछ नहीं है। फिर वही बात आ जाती है ना कि अगर वो बाद में जाके बदल गया तो।
अगर पार्टनरशिप डीड में ये लाइन ही लिख गई कि whosoever want to sell it share, तो वो दूसरे पर्सन को एज
कभी
पर
बिकेगा ही
मार्केट।
नहीं वो शेयर, बैठे रहो मार्केट वैल्यू के लिए। प्रैक्टिकली जिसने कॉस्ट पे खरीदा है वो आपको मार्केट वैल्यू पे कैसे बेच देगा? चांसेस आर वेरी लेस। बट एनीवे, नाउ वी आर गेटिंग इन डाइग्रेस्ड, बट आई एम गेसिंग प्रैक्टिकली लीगली यस, मे बी आई थिंक व्हाट वैष्णवी इज सेइंग, यू कैन पुट द टर्म्स एंड कंडीशंस basis what is,
या
it is not a right, it is what you think is mutually agreeable. It is not your
या
right to
या
ask for a market value. It
करेक्ट
is a
करेक्ट
mutual.
करेक्ट।
ओके,
One
थैंक यू।
question, I think, Richa, I'm going to move to the next question. Gauri has a question actually related to the power of attorney. So I'm going to pick it up right now because I think it's a relevant question. Any way to obtain power of attorney when the parent is medically unable to communicate, sign, or make decisions? And I think this is a very important question, Vaishnavi, because the situation, like you mentioned, like there's a stroke, or now with rising cases of certain diseases like Alzheimer's, dementia, etc. Many times we are not recognizing it as younger people, like, okay, what's going on? And then by the time things get very, very out of hand, so, by the time you realize you need a power of attorney, now you don't know how to get that thing done. So,
Yeah. So see, power, first of all, let me clear that power of attorney generally is valid only through the lifetime of the principal. Once the
okay.
principal passes away, the power attorney is not valid. Also, there is one power attorney which in other countries we call durable power attorney. And in India, we have something called power attorney with an interest in the property. So what this means is that power attorney, power attorney with interest, is also valid after the passing off of the principal, or once he is mentally, he's in a position where he is mentally unstable and not able to take decisions on his behalf. So only in such situations there is one power attorney, which is power attorney with interest, that can come handy. So
But
what
if the situation is that the person is already now medically unable, that's her question. Is there any way to obtain a POA then?
see, if the person is mentally stable, he can understand, he can sign, although he is bedridden. If he can take all these decisions, then a power attorney is valid. If see this, because this is an thing of agency, it works like an agency. So if the agent, if the principal is mentally unstable, so definitely he cannot take decisions in such thing. But if he is on say bed rest or say bedridden, but he is able to identify what he is doing when he is signing this power attorney, then in that case he can definitely sign this. Therefore, it is advisable, if you think your parents could come in such a situation, it is always advisable that you get a power attorney with interest signed Because even later on, if they pass away or their mental capacity is, disturbed, then at least this power attorney, this type of power attorney will remain valid. Hope I have answered your question, Richa. Yes.
That's Gauri's question. Zenat has one. Just an extension, sorry, since it's a joint property. Zenat, should I read it out? She's written that just a thought, I could be wrong in a joint property. Can we divide the area?
Yeah. This is what we are saying. See, if you have a house and you have two doors, say, one is in this road and one is in this road, and you want to have a wall in between, you can have it. Get a partition deed, put on a wall, and the share is determined, right? So that is possible. We were talking about a situation when there is a flat, and how do you divide the flat into two? Because there would be an entrance, single entrance for the same. If there is an independent house, if you have independent floors, then nothing is stopping you from occupying your share of the property.
Thank you.
Most welcome. Now let's go to Priya. What do you think Priya's mother could have done differently in order to secure her?
Family settlement.
Okay. But like she only wanted to give this flat to Priya. What instrument she could have signed? Generally, we gift each other on birthdays, anniversaries. What do we give each other?
Gift deed.
Yes, exactly. So while Priya's mother was there, she could have signed a gift deed in Priya's name. So what is a gift deed? There are two parties, donor and donee. So the donor voluntarily, out of his or her free will and without consideration, no money is involved. This is just out of pure love and affection, gives the ownership of that property in favor of the donee. Okay, so once a gift deed is signed, now the donee becomes the owner of that property. This is very important. And the gift has to be without consideration. No money has to be involved. It is purely out of love and affection. And once the gift deed is done, once the gift is accepted by the donee becomes the owner of that property. The donor gives up his stake or his claim on that property. So had Priya's mother given her the gift deed, the property would have become Priya's in Priya's mother's lifetime. So the brothers couldn't have come when the mother passed away and stake their claim to that property. This would have secured Priya during her mother's lifetime.
We have two questions, Vaishnavi.
Yes, yeah.
Hang on. We have two questions, so we'll take that. All right, lovely. I have three questions, okay. So, Samantha, you want to ask or do you want me to ask? You all can unmute. It's a small group. You can unmute and if you all are okay.
Yeah, my question is, how is a gift deed different from a will? Is it, will comes effective after the death of a person, gifted during the lifetime? So if you
Yes,
can...
correct. So will comes into effect after a person passes away. So till the person is alive, the property is still in the name of the testator or the person who has made the will. It will come into effect. The transfer will happen only after the testator or the person who has made the will passes away. Whereas in gift deed, the transfer is instantaneous. Once you sign the gift deed, the property is automatically transferred to the donee. The donee becomes the owner of that property. The donor gives up his claim. He cannot claim it afterwards that this is my property. He cannot, give it by will
You can't
also.
take the gift
Now,
back,
yeah,
basically.
yeah.
Gift is
Now the
given now.
property becomes the donee's property. He can do whatever he want to do. Yes. So it is the time of operation.
But the
Difference
mother
between
could have made
time.
a will also, na. Agar
Yes,
lifetime mein
yes,
he doesn't want to
yes,
give it, then she can
yes,
put it
yes,
in the will. That would also be valid, right?
yes.
Like then the
Yeah.
so I think the next two questions are kind of, I think, linked to that. There's a question which
Can I ask
is
here?
yeah. Ask Rachna.
Yeah, hi Vaishnavi. I have a
Hi.
question related to gift deed. One is whether since you said gift deed and will are two different things, if there is a gift deed into place, it supersedes the will is my first question. And second is, like will, what I understand is it compulsorily doesn't need to be registered, right? Same way, is it for gift deed? Can it be registered, unregistered? If you can, share.
Yeah, sure. So to answer your first question, yes, gift deed supersedes a will, because see, you are signing the gift deed while you are alive. So the transfer is instantaneous. The other person becomes the owner of the property at the moment you sign the gift deed and get it registered. Okay. So a gift deed has to be signed and registered at the office of the registrar. Without a registration, a gift deed is not valid. And yes, I think I have answered your
Got it. Thank you.
second question as well. Yes.
Last one is if the gift deed can be challenged.
No, actually, if see, what is there is you are signing a gift deed, you are going to the office of the registrar out of your own will and volition. If everything is voluntarily, that is what we are saying. If this transaction is voluntarily, then it cannot be challenged. But yes, if you can show that this was fraudulent, there were circumstances, overlying circumstances, if you can prove, then maybe this can be cancelled. But otherwise, the transaction is very much valid, because everything is getting noted in the government registers and everything. Therefore, the word voluntarily is very, very important. If you're doing the transaction out of your own will, then you cannot challenge it. Any more questions? It's good to have questions, actually. It shows that everyone is engaged in the conversation.
Prajakta, you want to unmute or do you want me to say it? Depending on where you are.
Yes, I am here. Thanks, Neha. So, my question is, what are the tax implications on gift deeds? Like, for example, I'll give you, if my father gifts me a house, probably on, as part of the gift deed, and then if I buy another house, how will this be a
See,
situation in terms of tax? Yeah.
agar it is within the family, as you are talking about your father gifting a property, us pe tax nahi lagta hai. But if you are not related, say I want to gift something, I want to gift my flat to a friend, us pe tax lagta hai. So within the family hota hai, within siblings hota hai, family members hota hai, to us
Niece,
pe tax
nephew,
nahi lagta hai.
niece, nephew,
Nahi
nothing.
लगता है, yeah. Within the family nahi लगता है, outside the family लगता है tax.
Okay, thanks.
Should we go on? Yeah. So, yes. So will. What is a will? So will is a document that you create within your lifetime, and through the document, you tell the other person how you want your property to be distributed when you are not around. So this is very, very important. And also it is very important to understand that a will comes into operation only and only after the death of the testator. While the testator is alive, testator means the person who makes the will, while he or she is alive, he or she can change his will n number of times. Okay? The transfer of property would only happen according to the last will. And the transfer would also take place after your lifetime, after your death. So while you are alive, even if you are making a will at 30, 35, 40, the property is yours. You do not have to worry that once I make a will, I'm giving it to another person. No, that will go to another person only after you leave this world. And one more thing, I think I missed this. Rachna asked me, is it compulsory? Is it mandatory to register a will? So no, it is definitely not mandatory. It is just optional to register a will. But we always recommend, for more authenticity, we recommend that it is better to get it registered at the office of the nearest sub-registrar. But even without registration, a will is as much valid, provided the will was signed, because this is very essential that you have to sign a will in front of two witnesses. These witnesses need not know what is there in the will, what you have written, which property you have given to whom. But they should have seen you sign that document in front of their eyes, that you have voluntarily signed this document out of your own free will. That's it. Registration is not compulsory. Yes.
Vaishnavi, I think we missed one case, which is Neha's case. This
Oh,
one.
yeah.
Yeah.
So what do you think Neha signed when she gave up her share? What could have been those papers? Anything? Any guesses?
NOC.
No. So it's basically, it's called relinquishment deed, sort of an NOC. Yeah. So relinquishment deed is a document that you sign giving up your share in favor of the other person. So these two persons have to be heirs. So both of them should have some interest in that particular property. It couldn't be signed. Like, I can't sign a relinquishment deed in favor of Neha because we are not related. But siblings can sign because they both had some interest in that particular property. So when one heir, let me put it this way, when one heir gives up his or her share in favor of another heir, that is through a document which is called relinquishment deed. And once he gives up his share, then the other person becomes the owner of that particular share. So this is very common in our society where, earlier women were not, they did not know about these instruments, but of age, they were asked to sign, ye document sign kar do, aise karke. It happens at times, right? When a father or mother passes away, and when the brother wants to take control of the entire property, he gets this document signed by the sister so that later on the sister cannot come back and claim her share in the property. So this is very, very important. Relinquishment deed. You should know.
Touched a very important chord. There's like so many questions I have on this.
Okay.
So let me start with Zeenath. Difference between relinquishment and release deed.
So, as I say, relinquishment deed is only between heirs. So you have to be related. It could be brother and sister, sister and sister, something like this. But release deed could be between others as well.
Okay.
Thank you.
Srilata, should I ask you a question? If you want to unmute, please do that. Okay, let me ask. She's not unmute. What could be the precautions to be taken with joint will and intestate assets?
Joint will is generally a single will written by the spouses. So me and my husband, we write a single will. That is called a joint will. And what was the other one? Sorry.
The precautions she wants to know. What precautions should be taken in such a case with intestate assets?
Okay, so interstate succession, see, when it comes to interstate succession, it is according to the laws, the rules that have been laid down in our statutes. So, for, say, let's talk about women. It's very, very important. So, our succession, our interstate succession is governed by Section 15 of the Hindu Succession Act 1956. So, what it says is, if I have a property, first, it will devolve upon my husband and my children. If I do not have a husband and children, then it will go to the heirs of the husband. Very interestingly, this is very interesting. So heirs of the husband would be husband's father, mother, brother, sister. And after this, it would go to my parents, the wife's parent. So priority is given to the in-laws, and my own parents, they come on a lower pedestal. This is how interstate succession for Hindu women takes place according to law. Although,
But hasn't this been contested recently? I mean, there is a case, right, which is
no,
there against
this
this.
is
No,
for
there was a
now. This
case.
is this is the position.
This is still, this holds. Even
Yeah.
in case of self-acquired property, like if I buy
Yeah,
a property in my
This
time,
is the case in case of self-acquired property. Yes, you're correct. There is a dispute that is going on. Let's see what the judgment
there's a
comes out.
dispute which I think
The matter,
has
I
been.
think, is in Supreme Court, Honorable Supreme Court, not sure. But
There is
yes,
there is a
because
matter.
this is the point. Because for my self-acquired property, therefore, it is very, very important if you have a self-acquired property and you want, in case anything is to happen to you suddenly, because life today is very, very unpredictable. And if you want to leave something in for your parents as well, it's very, very important that you write a will. Otherwise, the property will only go to your husband and your children. Your parents won't get anything. And if the husband and children are not there, then it will go to your in-laws. After your in-laws, it will go to your parents.
So in this situation, having a will is very important. Zenith has a question, how to secure a will? Because there are a lot of, people who are contesting the will and things like that.
Yeah, for that, we always recommend get it registered. Registering a will is hardly 10,000, 15,000. But when you compare it to the amount of your assets, this 15,000, 10,000 is like peanuts. So this is the best way to get your will secured. Get it registered at the office of your nearest sub-registrar.
So they say that even supplying a medical certificate and if
Yes,
there are any
this
other
medical,
things.
yeah. So this medical certificate, it comes handy when like an elderly person, it could be contested that this person was not stable when he was signing his will. So for youngsters, medical certificate is not compulsory. Like if you are in your 30s, 40s, 50s, we believe that you were mentally fit to take the decision with regard to your assets. The need for medical certificate only comes when, say, a person is bedridden. Then it could be contested that this person may not be having the mental capacity, to take decision regarding his assets. In that case, will also affix the doctor's certificate certifying that the person was mentally stable and fit to take such rational decision on his own. This certificate comes into operation then. For youngsters, it's not necessary.
So as when we go to like a registry office, there is a video recording of, the entire process. So, and it's all happening there in the authority. Do we still need to affix the medical certificate, even though it's like a video recorded session?
See, if you are going and if the elderly person is going, I'm talking about someone elder. Let's take a medical certificate, someone elder. It's not compulsory. There is nothing in law as such which makes it mandatory to have this medical certificate and record. So even if this medical certificate is not there and the elder person goes to the registrar's office, signs his will in front of the registrar, then there is no requirement of medical certificate.
Okay, thank you.
Yeah. Medical certificate, when do we generally attest is, say, as I told you, right, the will has, it is not mandatory to get a will registered. So you can have a unregistered will as well. You can have two witnesses coming over to your place and another person signing it. In that case, if someone challenges that this person was mentally unstable, in that case, this medical certificate comes into handy, that you had a doctor certificate certifying that this person was mentally stable to take such decision.
Okay, got it.
Let's move on, Vaishnavi. We have few questions, but I think you should complete because there are lots of questions which will keep coming up. I think, but we also have to manage time. So let's move to the, yeah,
Yeah. So will I have talked about. Let's
will
talk
you
about
talked about.
succession certificate. So succession certificate is a certificate that is given by the district court generally, certifying that the person is the actual heir of the deceased person and you can transfer the money to him or her. That's it. So generally, this is succession certificate is used for movable properties, generally money transaction. So if you do not have a will and you go to a financial institution to claim this amount, they will ask you, if you do not have a will, they will definitely ask you to get a succession certificate from the court before they can release this amount to you. And
There is a question on legal heir certificate being different from
yes,
succession certificate.
yes. So a legal heir certificate is a certificate which in all the states except Maharashtra, you get it from a municipal office, municipal corporation office, all of these things, tehsil, certifying that the government official certifies that these are the legal heirs of the deceased person. So he certifies that these are the people that the deceased has left behind and these are the person who can stake claim to the property or to the assets of the person who has died. That's it. Generally, it is helpful when a person has died, although everywhere you go, they will ask you for a legal health certificate, even if you have a will, to be honest. But with a will, you can easily stake claim. If you have a will, then the person will not ask you to get a succession certificate from the court. So that way you are safe. And see, here, if you do not have nominees in bank accounts, if you have a nominee in bank account, they will definitely release the money in your favor with a few documents, with legal heir certificate, to be honest. They will look at your IDs, your documents, maybe your marriage certificate, and then legal heir certificate, and they will release the amount to you. So the difference between legal heir certificate and succession certificate is, for succession certificate, you have to definitely go to the district court and get it. For legal heir certificate, you get it from a tehsil or a municipal office, except in the state of Maharashtra. In the state of Maharashtra, you get this legal heir certificate from the court.
Okay, so I'll pick two questions. Pia says, don't demat accounts have nominees?
They do
Yeah.
have nominees. If nominees, yeah, generally they give the amount. But see, if there are paper shares and all of these stuffs, even if they have nominees, they won't give you the money until and unless you have a succession certificate. Because they want to make sure that they do not give it to the wrong person, right?
So basically, having a legal heir certificate, succession certificate, and a will all are required.
Succession certificate, if will is there, then you do not need it. So generally, when a person passes away, you would need a death certificate. In most of the cases, I'm telling you, death certificate, legal heir certificate, and a will. These three will do. In most of the cases.
Gauri has a question. Succession certificate will have names of all class 1 heirs.
Sorry?
Succession certificate will have names of all class 1 heirs.
Yeah. Yes.
Yeah. I have one question now. One is around, okay. Is there more that you have to cover? Is there one more?
No,
You
we
are
are
we done?
coming
Can we
towards
take
the
up questions now? Ladies, I
yeah.
know we're over time. Vaishnavi, I know
No,
we're
no,
over
no.
time. Can we take
We'll be
3
more than
minutes
happy
more?
to like answer whatever
Okay.
we can.
So I think there are two very important questions. Oh, there is this one probate one as well.
Yeah, I wanted to cover probate as well.
Okay. Aruna's question, I think Aruna's question has been waiting for a while. Aruna, are you there? Would you
Yeah,
like
I'm
to?
here. Yeah.
Okay. Yeah, please.
So let me just read my question. If my husband is trying to hide his ancestral properties, can I demand the details of the will written by his deceased grandfather, which is self-acquired?
So you are trying to say that the grandfather had self-acquired property,
Ah,
and then he has given the self-acquired property to someone by will.
yeah, he has mentioned it is passed on to the legal heirs.
No, like has the husband's grandfather given it to him by will?
He has just mentioned it can pass on to the legal heirs.
Okay, okay, understood. So see, once this property has passed on to, first of all, this is not ancestral property, to be honest. Once a grandfather has written a will, the people who would be getting this property, they would have their own specific shares, and they would also get it as a self-acquired property.
Okay.
Yeah. So this is, we sometimes confuse it, but this is not an ancestral property. For grandfather also, it was a self-acquired property, and when it is passed on through the will, for the other person who gets it, he would also get it as a self-acquired property. So the other person could, manage it in whatever way he wants to. So in such case, you cannot actually ask him.
Okay. Okay.
Yeah, yeah.
I think this is linked to a question. Sorry, Pratibha, I had missed this question earlier. Self-acquired property by father-in-law, written off by will to son clearly, stating the divorced daughter-in-law and the grandchild has no right to claim anything he's given his son. What the minor grandchild can do, from what I know, property acquired by will is also considered self-acquired.
Yeah, this is what I'm
So in
saying.
this
Say
case,
he has given it. Actually, we prepared a will for somebody. So this person, he had undergone a divorce, and the grandmother made us write in the will that if once she passes away, the granddaughter won't get anything from her estate. So it is very much valid. If you have specifically excluded someone from it, the other person cannot stake a claim to it.
okay. That's like kind of like a dead end, basically.
Yeah, yes, yes. If it's a ancestral property, that is different thing. Like it's been passed on from generation to generation, and there has not been any partition. Then it's totally different. But in these kind of situations, that is the dead end. You cannot stake a claim.
All right, ladies, if I'm getting lots of people writing questions now, I'd just like to open the floor. Please pick your questions if I've missed any. Let's take
Yeah. So
another two,
yeah,
3 minutes to do the questions and then I think we will let them go. I also know that You Are Insured has some interesting offers. Maybe you can just share that for the
sure,
tribe
sure. What I'll do
right
is
now.
like, let me take 2, 3 questions, and then I'll pass on the baton to Sunil, who is our founder, and he can like carry forward it. He can tell you what offers we have, like everything. Let me clear your legal doubts. Also, like if you have 2 minutes, let me just complete what a probate is. So probate is granted by the district court in the areas of, it's mandatory to get a probate for a will in Mumbai, Kolkata and Chennai. In all other places, you do not need a probate. So probate means you going to the court and the court authenticating that yes, this is the original will of the testator. That's it. So it is mandatory in the cities of Mumbai, Chennai and Kolkata. In rest of the areas, getting a probate from the court, that is not mandatory.
Right. Okay. Then I have Amrita has a question. What about in family business? Amrita, are you there? If you could just elaborate your question.
Hi, I'm here.
Hi.
Hi.
So I was just asking, like, what happens in family business scenarios, like, um, when the elder one, who's the main establisher or the owner, passes away, then how does those things work? Like, huh?
Yes. Yeah. So we'll have to see what kind of a business it is. So whether it's a private limited company or a public limited company or a partnership or an LLP or maybe a single sole proprietorship, we have to see, and accordingly we have to see what terms are mentioned when this business was established, and accordingly we can answer this question, to be honest. So it depends upon what kind of company has this elder person established.
Yeah, it is kind of like what I was asking about. It is kind of like a uh, society, so with different members and all that. But the business that runs, it's on a private property. So the property is of the owner, and the business that runs on it is of a society, or like it's a group of people. So like. How does that work, like if later on, like somebody wants to do something different on the property, or somebody in the business wants to do some things on that property, so how does the ownership works in that scenario?
See, here we'll have to see, like, that is what I'm telling you. We'll have to see what kind of business it is, to be honest. You would be having some papers, right? In those papers, something would be written about how the business would pass on to the next generation. So you'll have to go through that papers. Once you'll have to figure out what kind of a thing, what kind of a business it is, and then only, to be honest, we can answer this question.
Okay, thanks. Like,
Guys, for
yeah,
one-on-one
thank you.
questions, I think, thank you, Amrita. We are running out of time. I quickly would request, you are insured. I know that you all are giving out slots. Can you please quickly share
Yeah.
that with the group
So
so that,
yes.
they
So
all know where they can reach out to you? And,
now
yeah.
I will request Sunil to come forward and tell you all what all we can do post the session. Sunil, over to you.
Yeah. Can you go to the slides? Next slide. Yeah. I think all of this is covered, right? All of these are best practices, and most probably Neha will be sharing this presentation, at least the recording, so you can go through with that. But I want to focus here. So can you put it in? Yeah, thank you. So how many of you think these are imaginary stories? Anybody think about that? Just a
No.
honesty. Right. So all of these stories, these are from our friends when I spoke to them, when we spoke to multiple lawyers, when we spoke to multiple people. These are the stories from them. These are the stories which we know of. These are the stories which we listened about from multiple different people. And in fact, there is one story that is my own sister's story that actually kind of motivated me to do what I'm currently doing. So I saw how life turns around in a moment and throw you off guard. You become vulnerable, helpless, and burdened. And life is so unpredictable. We never know what happens and when it happens, right? But are we going to wait for it to happen and then run around, or are we going to plan and mitigate this? That is what your insured is. What we are trying to build here is a community where we know the pain, where we want to solve that for you. What we want you to consider is these are the challenges, these are the misconceptions. So why not plan on it, right? Ask yourself this question. Can you board a train which you don't know where it is going, and you get off a station, you don't know that place? Can you feel safe? Can you feel secure? Can you feel you have full control? No, right? That's the kind of situations which we get into if something suddenly happens. These are the emergencies which we don't plan. But can we plan something to mitigate these kind of issues? Yes, we definitely have that option, right? That is what we are trying to build. And the reason why we call ourselves a legal tech company is, of course, you can go to a lawyer, right? Lawyer can only do the legal things, but what about the other things? That is where we have an overall kind of platform where we want to help you with all these things, multiple different things, not just the legal advice, not just the legal representation, not just doing a will registration for you, but also doing claims on behalf of you for the banks, doing claims on behalf of you for vehicles, bank accounts, fixed deposit, all these kind of things. We run around all of these places to help you get your claims done. That is where we are different from a lawyer. So uh, to kind of understand where you stand, the first place you want to go is this QR. I want you to scan this. Keep the tab open. You can fill it afterwards. But what this means is this is a small quiz. Okay, it is just trying to identify what are your gaps in the estate planning. Right, you would have some gaps. You have a lot of questions. So all of these questions, why they are coming is because there are some information which you don't know. There is something which you are not clear. Probably you need to speak to your husband, probably you need to speak to your father about this. But how would you know what you need to discuss, right? That is where you take this quiz, and then you will understand what are these gaps. Schedule a call with us, and that information will be available if you scan this and submit. There will be a link where you are going to get the consultation link. So that is something which I would strongly advise you to do. Also, please share with any of your loved family members if they want to take this quiz and participate in this. That is something which I strongly advise you to do. I'll wait a moment here to kind of for you to complete the scan. Okay, I hope you did that. Yes. You and only you have the power to decide what should happen to your kids, your family, what should happen to your properties, right? Don't give up that control to anyone. If it is for others like relatives or court, why are you giving up that control? That control should be yours, right? You always wanted what's best for you and your family. Why would you leave it to someone else in case of emergency? So have that control. That's the power of estate planning. And a lot of people ignore that. It is as powerful as financial planning, I would say, if not less, if not more, at least as powerful as financial planning. You definitely need it, right? So that is why I would insist all of you to take it seriously. My sister's story was the reason I started, like I mentioned. This is a community of sisterhood, right? You named your community as Womoneysta, right? Sisterhood. So you're talking about sisterhood. So you're all like my sisters. So do what is good for you, and talk to me like your older brother. Feel free to reach out to us, any of us. I mean, either Vaishnavi or me, and we'd be happy to help you. That's our promise. So you can go to the next slide. Yeah, this is our contact information. These are our social media links. And this is where you can send us a WhatsApp also. So the offer which we were to kind of announce is you will be getting an offer for people who are coming in and want to make a will with us. You will get it for a 50% discount if you do it before end of December. That's a very good end of year plan, right? A lot of people plan New Year things, but you could plan something in the previous year for the new year to start 2026 in a better way. That is one thing. You can also get our offline platform access. I mean, the online platform where you keep all the information, because we were mentioning about the information which you don't have. That is a big gap. It is easy to kind of misplace documents. It is easy to kind of forget about bank accounts. You know how much money is lying in the RBI and IRDA, right? 2 lakh crores. That is money which is not claimed by legal heirs. Why? Because they don't know that bank account is of their husband or father, right? Now, all of these platforms are coming up with additional features to tell you, give this mobile number, search if you have an account, submit the document and get it. Why should they be just living in the dormant state without generating any interest, why can't you take it immediately, right? So the information is essential. So our platform, online platform, is free to use. You can sign up and you can keep all the information there. It is a secure platform. If you want to kind of keep the same thing in an offline way, we do have a book where you can record all of these things. It is structured in a way to simplify all of this document access or the information access that you will get for 50% off. Then the other offer is first 30, you will get a free consultation with us. If you want to just schedule the call using the link which you get. When you submit this quiz, right, you will get a link, or you will also get a link from Neha and us after this meeting. So you can use either of them. Schedule a call with us. That is going to be a free discovery call to help you understand what is your position, what is your stand and in terms of estate planning, and we can guide you from there. So hopefully this is an interesting, and I hope you learned a lot about all these different situations, what kind of remedies you have, what kind of legal power you have. Unless you know your power, you won't utilize it, right? So this is like discovering your strength. So I hope this was useful for all of you. Yeah, over to you, Neha.
Thank you so much. Absolutely, Sunil, Vaishnavi, thank you so much. Everyone, before you leave, few things, we'll be sharing the recording. I'm also launching a quick little poll for the ones who are still here. We are way, way, way over time for our session, but I think it was so important and so engaging. Shows how important this topic was. We will be sending the recording. We will be sending the offers. Please make sure you use a lot of questions which went unanswered. You do have access for a free discovery call. Use that benefit. We also, as Womoneysta, will be partnering with You Are Insured for any of our clients, our wealth clients who are looking to get their services. So feel free to connect with Rachna, me, Krutika, Ishika. You all know the team. Yeah, so from our side, that's the hope that we continue to bring more such topics, more such information. Please do just take a second to put the feedback. It means the world to me and the team who is constantly trying to get you all new, important, essential things. And finally, thank you, Vaishnavi. You made it so simple. I made notes. Hopefully, the next time I'm sitting in front of a lawyer, I do remember words like partition deed, succession deed, relinquishment deed, and things like that. So thank you for making it personally easy for me. Wonderful, wonderful session. I think you can see the comments. I totally agree. Thank you, everybody. Have a wonderful weekend. Thank you, the team at Your Insured. We hope to continue interventions. Maybe we should do more interventions soon with some new topics. And yeah, thank you, everybody, for your time. Have a wonderful weekend. Bye bye.
Thank you
Thank
so,
you.
so much. Thank you. Take care. Bye-bye.
Thank you.
Bye.
Thank you.
Thank you so much.